right. A very pleasant, I guess I can still say this. We have 3 minutes left. A very pleasant good morning to everybody, at least on the East Coast. The East Coast. There's 3 minutes left. This is the 2025 legal update, two CEUs for licensed Florida managers. And just to clear up any confusion, this is not going to garner any kind of CEU for HOA board members, at least not yet. We haven't, no provider has had those approved by the state as of yet. So this will get credit for community association managers if you still need that two legal credits. This is stemming from the 2024 legislation that passed and is already in effect. So this is not the names of the legal update classes are always very confusing. It's called the 2025 legal update, but this is the approved class that covers the legislation already in effect that passed last July. So just keep that in mind. Everybody's welcome to hang out and learn as well. And Kirsten always updates these slides as things change and trends change. So even if you took this class a few months ago, you're going to learn something new today. I guarantee that. We're collaborating today with the fine folks over at Rizzetta Company. I'll introduce them in just a moment. While we're waiting for everybody to populate, we still have about a minute and a half before we get started. Please do one thing for me right now. Press that chat button on your interface, okay, on your Zoom interface. It's going to say chat is disabled, but there is nothing for you to enable. We can still send information your way. And a little bit later on, towards the end of the webinar, we're going to place a link into that chat area. Clicking on that link will take you to the required evaluation. So please press the chat button now, just simply so it appears. Don't worry that it says disabled. The way you're going to ask questions during the course of this presentation is with the Q&A module, not to be confused with the chat module. So the Q&A is where you will ask your questions. Keep in mind, though, whatever you hear today, if your question gets answered, what you hear during the presentation itself, nothing is to be considered as legal advice. This is strictly educational in nature. And should you have any questions beyond the scope of what you hear today, always contact your association counsel, your managers. Keep that in mind, okay? Not legal advice. In addition, the slides today that you will see, they will be available for everybody, so you don't have to take crazy copious notes. After you fill out the required evaluation at the end and you hit submit, there will be a screen that has everybody's contact information as well as a link to download and save the slides. So you'll have that. Lastly, the recording. This class is being recorded. It will be on Rizzetta's website within a few days after the course. It'll be on Kaye Bender Rembaum's website within a few days after the course. So you will have the opportunity to review this afterwards as well. Just keep in mind, if you share the recording with friends, colleagues, other managers, the only way you get credit is by being here live. Watching a recording afterwards is not going to get anybody credit. So just please remember that. Please keep that in mind. So with that said, we're 1 minute past the top of the hour. I want to now turn it over to our co-hosts from Rizzetta Company today. This is Taylor Nielsen. Taylor, my friend, take it away.
Yeah. Thank you. Good afternoon, everyone. And thanks for joining us today, and welcome to the first edition of Community Insiders, a speaker series designed to empower board members, property managers, and other industry leaders with essential insights and effective community management. As Jeff mentioned, my name is Taylor Nielsen. I'm the Business Development Director with Rizzetta Company. Rizzetta is a full-service community management firm servicing communities across the state of Florida. Whether your community is small or large, our resources and dedication are going to ensure the highest level of operational success for your community. Also here with us is Carla Castro, our marketing manager for Rizzetta Company, who's going to assist us with some questions throughout the Q&A feature. Next, I'm excited to announce Kirsten Henza of Kaye Bender Rembaum as our first speaker on the Community Insiders series. Kirsten's been practicing law since 2006 and joined their firm in 2010, focusing on community association law and assisting the firm's clients with all aspects of community operations. Thank you for being here today, Kirsten.
Thank you. And thanks everyone for attending, taking time out of your busy schedule to listen to this legal update. As Taylor mentioned, my name is Kirsten Henza. I am a partner and managing attorney of the West Coast office for the firm, which is located in Tampa. We are a full-service community association law firm, which means that we represent exclusively homeowners, condominium, and cooperative associations in the state of Florida. Our main office is located in South Florida in Pompano Beach, but we have other locations, Palm Beach Gardens, Orlando, and again, the West Coast office here in Florida. All right, so without further ado, let me share my screen.
And while Kirsten's doing that, just for those of you that may have come in just in the last couple of minutes, please press the chat button on your interface one time, simply so it appears. That's where we're going to place the link for the evaluation a little bit later. Kirsten, back to you.
Thank you.
Okay.
All right, here we go.
Yeah, we see it. Good to go.
Thanks. All right, so like Jeff mentioned, this is the 2025 legal update. So we will be discussing laws that went into effect July 1st of 2024. As many of you may be aware, the Florida governor did sign House Bill 913 recently, and those laws will go into effect July 1st of this year. We are in the process of reviewing the entire House bill, which is 191 pages for those that are interested in reading the bill at your leisure. So once we've reviewed and digested the new changes to the statute, we will be creating a new legal update, and that will be rolled out closer to the fall. Okay, so be on the lookout. We will be teaching a legal update of the new changes in the next few months. All right. So let's start with community association managers and management companies. All right. There's a lot of information, folks. I'm going to try not to read a lot of this, but unfortunately, there are a lot of words in the statute, so we try to condense this as best as possible. All right, now the next few changes to House Bill 1203 only affect homeowners associations. So as of right now, nothing of what I am about to discuss affects condominium or cooperative associations. So a licensed community association manager has to attend at least one membership meeting or board meeting annually. Okay, so many of you, you might have a management contract with your property manager. Typically, your management contract will include a list of services, and among them might include attendance of board or association meetings. Well, now by law, your property manager is required to attend at least one membership or one board meeting. Of course, your contract can require additional attendance for additional charge. In addition, your property management company is now required to provide members certain information, and we've identified the information here. They have to identify the name of the contact person, contact information, hours of availability, as well as provide the name and contact information of the property manager that will be servicing your community. Okay. Now, they also have to provide a summary of the duties for which the manager is responsible. There is a website requirement that we'll talk about momentarily, and that actually went into effect January 1st of this year. So for those associations that are subject to the website requirement, you now also have to post all this information from the previous slide on your website. Now, your property manager or management firm has to update the association and the members of any changes in the information from the previous slide within 14 business days of the change. The property manager also, upon request of any owner, has to provide the member a copy of the contract, management contract between the association and management company. Okay, and that contract has to be part of the official records. Again, these are only changes that affect the HOAs, which are governed under Chapter 720 of the Florida statute. Does not apply to property managers or management firms that currently serve as the condominium or cooperative associations. Now, the department, the DBPR, the Department of Business Professional Regulations, can require no more than 10 hours of continuing education annually for property managers. And then biannually, so every 2 years, each property manager has to complete at least 5 hours of continuing education that pertains to homeowners associations, 3 of which have to relate to record keeping. Okay. So again, this is only for property managers that manage HOAs under Chapter 720. Now, the following information does apply to both condominiums and HOAs. So your property management firm has to return official records within its possession within 20 business days after either termination of the contract or within 20 business days after it has received a written request for the records from the association, whichever occurs first. Okay, so it's a 20 business day time frame. Now, your management company may retain records necessary to complete the end of the year financial report, okay? And they can keep them for up to 20 business days. However, if the association refuses to provide records to your property management firm for purposes of preparing this financial report, then you're essentially relieving your property manager of the obligation to complete this financial report. So just be aware of that. Now, if your property manager or management firm refuses or fails to return any of the association's official records within the 20 business day time frame, okay, then not only does that subject the property manager to suspension of its license, his or her license, but also subjects them to a civil penalty of $1,000 per day, up to 10 business days, okay, which will begin on the 21st business days after the termination of your management contract or receipt of the written request for records from the association, whichever occurs first. Okay, so the legislature is definitely treating the failure to return association records very seriously. Okay, this also applies to property managers that manage both condominiums and HOAs. And this has to do with financial interest disclosures. So property manager, including directors, officers, or persons with financial interest in the management firm or relatives of such persons, must disclose to the board of the association any activity that may be reasonably construed to be a conflict of interest. Okay, now under the statute, there is a rebuttable presumption of a conflict of interest if either of these two things occur. Okay, so either the property manager or directors, officers, or persons with financial interest in the management firm or any relatives of these individuals, either they enter into a contract for goods or services with the association, or these individuals have a financial interest in some entity or corporation that either has or proposes to enter into a contract or a transaction with the association. And obviously it's for services other than management services. Okay, so if either of these two things occur, there's a presumption of a conflict of interest, which requires disclosure. Now, if the association receives a bid that exceeds $2,500 for goods or services other than in connection with management services, okay, then the association has to obtain multiple bids from other third-party providers for the same service or goods, okay? Now, if there is an activity or transaction that is the subject of a conflict of interest, then the following has to occur. The proposed activity has to be listed on all contracts, and then all transactional documents, so any contract that the association is looking to enter, okay, that could be subject to the potential conflict of interest, that has to be attached to the meeting agenda of the next board meeting at which you're going to be considering this contract or transaction. The disclosure of this conflict of interest has to be also entered into the minutes of the meeting. Then the contract that is subject to the conflict of interest requires an approval of 2/3 of all the directors present at the meeting. Okay, so regardless of whatever your bylaws might provide as to the voting percentage that the board needs to obtain to approve or take action for purposes of approving contracts or transactions that are subject to a conflict of interest, that requires a vote of 2/3 of the board. And then the final thing is the disclosure. You have to disclose this conflict of interest at the next membership meeting. Okay. Now, if there is a violation of the foregoing conflict of interest rule, so if none of the disclosure took place, then the association may cancel the management contract with its management firm. And if that occurs, the association would not be liable for any termination fees or any liquidated damages that the contract might include for terminating early prior to the end of the term. Now, if the association enters into the contract with the CAM, including any director or officer of that has a financial interest in the management firm or any relatives, okay, then that contract is deemed voidable and it can be terminated upon the association filing a written notice terminating the contract with the notice providing at least 20% of the voting interest of the association. So you have to obtain at least a vote of 20% of the voting interest, 20% of your membership, in order to confirm the termination of the management contract. Any notice of cancellation of the management contract has to be provided by certified mail unless the contract provides for an alternative method of termination. And then the statute also defines what a relative is in the context of the conflict of interest, which means any relative within a third degree of continuity by blood or marriage. There was also Senate Bill 382. Okay, this has to do also with the DBPR. So the DBPR shall exempt from completing the continuing education requirement. They shall exempt any individual from completing the continuing education requirement for renewal of a license. Okay. If the individual holds an active license issued by the board and the individual has continuously held that license for up to 10 years. And no disciplinary action is imposed on the individual license. Okay. Now, the thing with this new law is that it is in effect until only January 1st of 2026. So on January 1st of 2026, this provision is set to expire. So really, it's, as of now, this is only in effect for 18 months. All right, let's shift gears. Let's move on to condominium and HOA official records and website requirements. So we'll talk about condominium associations first, and then we'll talk about HOAs. All right, so by January 1st of 2026, if you're in a condominium association that has at least 25 units or more, okay, now you're going to have a website requirement. You're going to have an obligation to maintain a website. Now, the current threshold is set forth at 150 or more units. So right now, only condominium associations that have 150 more units are required to have a website. Okay, but that is only until January 1st of 2026. At that point, it's condominium associations with 25 units or more that will be affected, and you'll be required to create and maintain a website. Now, 718, Chapter 718 of the Florida statute was also amended to clarify that email addresses and fax numbers are only accessible to unit owners if the owner has consented to receiving official notices electronically or has personally and expressly indicated that such personal information can be shared. Okay, so as many of you know, the only way that the association can provide official notices to owners by email is if those owners have consented to receiving those notices by email. Well, statute clarifies if you as an owner, if you've consented to receiving notices by email or fax, for those of you that still have faxes, well, unfortunately, that means that your email and fax number is now accessible to other owners. So just note that. The association has an obligation to also ensure that email addresses and fax numbers are only used for business operation and obviously cannot be shared or sold to third parties. And if such personal information is included in documents that are released to third parties other than unit owners, the association must redact the personal information before the document is disseminated. The statute also provides that the association is not liable for inadvertent disclosure of email, addresses, or fax numbers, unless, of course, that disclosure was made with a knowing, intentional disregard for the protected nature of the information. The statute was also updated to include additional documents that must now be kept as part of the official records. And those include all invoices, transaction receipts, or deposit slips that substantiate any receipt or expenditure of funds of the association, as well as copy of building permits. And then, of course, you also have an obligation to maintain copies of the board member certification requirements, okay? Again, this is affecting condominium associations. Additionally, while it seems common sense, the statute now also requires that official records be maintained in an organized manner that facilitates inspection of the records. And in the event the official records are lost, destroyed, or otherwise unavailable, the statute now imposes an obligation on the association to at least make a good faith effort to obtain and recover those documents that may have been lost, destroyed, or are otherwise unavailable. Another change, this was actually a positive change regarding official records. If an owner makes a request for an official record that has already been posted on the association website, while the association may fulfill its obligations to provide access to the official records by directing the owner member to the website. Okay, so There is a list of records that the association is required to post on its website. That's found in Chapter 718 of the Florida statute. And presuming that you have already posted that record on the website and an owner requests or makes a request for access to any of those official records, well, you can now tell the owner, well, those records are posted on the website, and that would fulfill your obligation to respond to the records request. Chapter 718 now requires the association, in connection with a records inspection request, to also simultaneously provide to the owner a checklist. Now, the checklist has to identify all the records that are being made available for inspection and copying, as well as identify the records that are not being made available. Okay. Now, this checklist has to be maintained as part of the official records for every requesting member for at least 7 years. In addition, now the statute criminalizes certain conduct in connection with a records inspection request. So presently, a director or member of the board or manager, if you knowingly, willfully, and repeatedly fail to provide official records, you commit a misdemeanor in the 2nd degree. And the term repeated refers to 2 or more violations within a 12-month period. Okay. But again, this does not really refer to any negligent or inadvertent mistake or failure to provide records inadvertently. If you miss the deadline for some reason, there has to be, again, a knowing, willful, and repeated failure. If a person, again, willfully and knowingly refuses to release official records with the intent to avoid escape, detection, arrest, trial, or punishment, that is now going to be equivalent to a felony of a 3rd degree. As well as if any person who knowingly or intentionally defaces or destroys accounting records that are required to be maintained by the association, or knowingly or intentionally fail to create or maintain accounting records that are required to be maintained with the intent of causing harm to the association or one of its members, that is considered now a misdemeanor of the 1st degree. All right, switching gears to official records for HOAs under Chapter 720 of the Florida statute. The statute now clarifies that official records have to be maintained for 7 years, with a few exceptions I'll point out in a minute. Okay. And here in these next few slides, we've identified basically the documents that would be considered the official records, which you are required to maintain. Okay, so I won't read them off, but they're here for you to review at your leisure. What I do want to point out on this slide is the first record, so bids received by the association. They have to be kept as part of the official records for a period of 1 year. So that's one of the exceptions to the 7-year rule. As well as on this slide, ballots, sign-in sheets, voting proxies, and all other papers and electronic records relating to voting by parcel owners. They also only have to be maintained for 1 year from the date of the election, vote, or meeting. Okay. So this is your second exception to the 7-year rule. So for example, if you if you've requested owners to approve an amendment to one of your governing documents, then the notice, the amendment, and all the voting materials associated with that vote only has to be maintained for 1 year, according to the current state of the law. All right, let's go on to website requirements for HOAs. Again, this is, and I think the next few slides will provide the time frame, but this is something that went into effect January 1st of 2025. Okay, so hopefully by now, if you're an association that has at least 100 parcels or more, you are required to create and maintain a website. Okay, so hopefully by now, everybody has already complied and you have a website and you're good to go. And if not, you need to get on it. Now, the statute outlines basically some of the requirements for this website. The association website or application must be accessible through the internet and must contain a subpage, web portal, or other protected electronic location that is inaccessible to the general public and accessible only to parcel owners. And then, of course, any owner that requests a username and password for this website, then the association has to obviously provide that username password so that owners can access this sub portal that only owners are allowed to access. Now, the association also has to ensure that certain information which is not accessible to owners is not posted on association website. Okay. And on this slide, we've identified some of the records or documents that are protected and exempted from owner inspection. Excuse me. So if an owner requests to see these records, they're not entitled to see them. They include certainly any document that is protected by attorney-client privilege. So that typically would include, among other records, legal opinion from association legal counsel to the board, information obtained in connection with the approval of a lease, sale, or other transfer of parcel. This would apply to those associations that have the ability, the authority in the governing documents to approve or disapprove sale, leases, or other transfers. Okay. So if you have that authority and you typically require a prospective buyer and purchaser to provide an application and a copy of the sale, purchase, or lease agreement, then, those records are confidential, as well as the background check that you perform on the applicant. So that criminal background check, as well as the credit score report or the credit report, all of that is confidential, cannot be disclosed to the owner or any other member requesting access. Personnel records of the association or management employees, that's also exempt from inspection. That, of course, excludes the management contract or any document that discloses the compensation paid to the manager or the employee. Medical records of any parcel owner. That could come into play if you have an owner that has requested, for example, an accommodation or a modification to the common elements or common areas and has provided certain information about their medical condition and a need for this accommodation or modification. And then, of course, social security numbers, driver license number, credit card numbers, email addresses, phone numbers, fax numbers, emergency contact, and any address provided by the owner other than that which is provided in connection with the official notice requirements. All of that is confidential.
Nick Kirsten, before you get to the next slide, this is inevitable, so I just want to address it real quick. I'm answering some questions in the Q&A, and I'm only answering questions that don't require an attorney's answer. So just keep in mind that if you see me answering some questions and not others, I'm not ignoring you. I just don't have that ESQ after my name. So even if I know the answer, I'm not going to answer questions that are intended for the attorney. In addition, when you type in your questions, I don't think I mentioned this at the beginning, do not make it association specific. Keep it general in nature to the content of the material today. We don't have your documents in front of us. We don't know your association, so we can't get too specific. Don't write a novel. Keep them short, sweet, yet concise. Kirsten, back to you.
Thank you, Jeff. All right, so as I previously mentioned, this website requirement now applies to HOAs with 100 parcels or more, went into effect January 1st of 2025. And the following is a list of the actual official records that have to be posted on the website. It is not the entire laundry list of official records that is set forth in the other slides a few slides ago. This is a more condensed list, so be sure that you review this list when you when hopefully you've created the website, but make sure you comply with that new list. I'm not going to read that. You can read that at your leisure, but essentially includes your governing documents, certain contracts, certain bids, insurance policies. Importantly, you have an obligation to post copies of notices of membership meetings on your website at least 14 days before the meeting. Okay. In addition to the notice, you also have to post on your website any document that is associated with that membership meeting. And it has to be posted at least 7 days before the meeting. So for example, if you have, if you've presented to the owners an amendment to your governing documents that you're looking to amend, then not only does the copy of the notice of that meeting, but also a copy of the proposed amendments need to be posted on the website. In addition to posting notices of membership meeting, HOAs now have an obligation to post notices of any board meeting, the agenda, and then any other document required for such meeting, and it has to be posted on the website no later than the date required for such notice. So as you may be aware, typically notices of board meetings have to be posted at least 48 hours prior to the meeting, unless of course your bylaws provide for a greater time period. And then under the statute, certainly any meeting at which the board is going to adopt a special assessment, or a meeting at which the board is going to adopt a rule concerning parcel use, those meetings have to be noticed at least 14 days prior. Okay, so whichever notice requirement applies, you've got to post notice of that meeting on the website within that time frame. The association is also required to adopt rules governing the method or policy by which official records of the association are to be retained, and the time period such records must be retained. In addition, a new requirement with regard to subpoenas from law enforcement. So if the association receives a subpoena for records from law enforcement, the association now has an obligation to comply and provide access to those records within 5 business days from receipt of the subpoena, unless, of course, otherwise specified by the law enforcement agency or the subpoena. And then the association also has an obligation to assist the law enforcement agency in its investigation to the extent permissible by law. All right. Now we're going to cover condominium and HOA board member certification and continuing education requirements. So we'll start with condominium associations. So it used to be for many years that in order for a board member to be certified to serve on the board, all you had to do was you could attend a division approved course, but you could also download a certificate, sign that certificate, basically attesting that you've read your governing documents and will, to the best of your ability, abide by them. Well, the new requirement is that condominium board members have to now do both things. not only sign that certificate attesting that you'll be upholding the governing documents, but also attend a division-approved board certification class. Now, for new directors, so new directors, you now have to, or actually this has been the law for some time, but new directors must be certified within 90 days of being elected or appointed to the board. The certification is valid for 7 years after the date of issuance, as long as you serve on the board uninterrupted. Now, the statute does require for condominiums for this board certification class to be at least 4 hours long. And the class has to cover topics such as milestone inspections, structural integrity reserve studies, elections, record keeping, financial literacy and transparency, levying of fines, and then notice and meeting requirements. I actually taught this board certification class yesterday, and we do cover all those topics in 4 hours. Now, if you are a director that was elected or appointed to the board before July 1st of 2024, then you have to comply with these new certification requirements by June 30th of this year. So in just a few days, this deadline will expire. So per the statute, if you were appointed or elected prior to July 1st of last year, you need to comply with these new certification requirements by the end of this month.
Well, if you see my mug on the screen, that means we're getting a lot of the same questions here in the Q&A. So I just want to clarify, while Kirsten is now covering certification, education requirements for board members, good opportunity to have some water there. This is a CEU class for managers. This is what I mentioned at the beginning. This class right here is good for managers only. No CEUs for board members. No provider in the state. No provider in the state of Florida has yet to receive instructions on creating the CEU class for condo board members. Okay. For HOA board members, we are in the process of getting courses approved for continuing education. So this class right now does not provide CEUs for board members, whether you're a condo or HOA, doesn't matter, or a co-op, doesn't matter. This is a CEU for managers only today. When it comes to KBR, when we promote courses going forward, we will make it very, very clear what each class is good for. Managers, board members, both, none, no credit, with credit. It'll all be outlined on there. Okay, I hope that clears things up because it's starting to clog up the Q&A here. Kirsten, back to you.
Awesome, thank you. So in addition to fulfilling that 4-hour board certification class, condominium board members will also have a continuing education requirement, which is what Jeff was just mentioning. So each year after being certified, board members have to complete at least 1 hour of continuing education relating to recent changes to Chapter 718 of the Florida statute. So, this legal update, hopefully by next year, will qualify to satisfy this continuing education credit requirement. So let's keep our fingers crossed. And then the association has to maintain proof of this, the certification and the education certificate for 7 years after the director's election or the duration of the director's uninterrupted tenure, whichever is longer. However, the statute does say that the failure of the association to have proof of board member certification and proof of educational 1-hour course certificates on file does not affect the validity of board actions taken. That is what it is. If a board member fails to fulfill this these certification requirements, essentially they are suspended from the board until the certification requirements are fulfilled. So just be aware of that. All right. Now moving on to HOA board member certification requirements. Similar, but not exactly the same. Excuse me. For newly elected appointed directors, they have to complete the department-approved education course within 90 days of being elected or appointed. And the certificate of completion will be valid for up to 4 years. Now, a director has to complete this education specific course, this board member certification class, at least every 4 years. Okay. Now, the statute doesn't specifically address what are the requirements for directors that were elected or appointed to the board prior to July 1st of 2024. However, the division, the DBPR, has issued I guess an unofficial notice that essentially if you were a director who was appointed or elected to the board prior to July 1st of 2024, you have up to 4 years from the date of your election to complete the new certification requirements. Okay. Now, the board certification requirement has to include training related to financial literacy, transparency, record keeping, levying of fines, and then notice and meeting requirements. Please note that there is no requirement in the statute for the HOA board certification class to be 4 hours long. Okay, there's no such requirement in the statute. The firm, we do conduct HOA board certification classes. I do these webinars often. In fact, I'm scheduled to do one next month, I believe July 24th, but
Correct.
you can confirm that. And typically we'll do this within 2 hours. Okay, we can cover all of the materials for HOAs within 2 hours. Now, for HOAs, in addition to the board member certification class, you also have continuing education requirements. And the number of hours of continuing education classes that you have to take will depend on the size of your community. So if your community has less than 2,500 parcels, you have to complete at least 4 hours of continuing education annually. However, if your community is larger and you have at least 2,500 parcels or more, you have to complete at least 8 hours of continuing education annually. So good luck to those who have who live in bigger communities. And then a director who does not timely file their education certificate is suspended from the board until he or she complies with the requirement. And the board can temporarily fill the vacancy during the period of suspension. Now, HOAs have to retain these certificates for up to 5 years. However, the statute also provides that the failure to have these certificates on file will not affect the validity of any board action. Okay. Just a minute. Seems like my slides are out of order. Not sure how that happened. Okay.
Ghost in the machine.
Oh, man. All right. Oh, geez. Okay. All right. Mandatory structural inspections for condominiums and cooperatives. Just note that It used to be that milestone inspections did not apply to single-family, two-family, or three-family dwellings with 3 or fewer habitable stories above ground. Now the statute provides that these requirements do not include, 4-family dwellings. So essentially, milestone inspection does not apply to single-family, two-family, three-family, or 4-family dwellings with 3 or fewer habitable stories. Okay, it applies to condominiums that have 3 or more habitable stories. Okay. A few definitions were amended and or added to Chapter 718. The definition for condominium property, it was amended to now include not only lands and leaseholds, but also improvements, personal property, and then all easements and rights pertinent thereto, regardless of whether contiguous, which are subject to condominium ownership. Okay. The statute also added a definition of hurricane protection, which includes, among other things, hurricane shutters, impact glass, code-compliant windows or doors, and other code-compliant hurricane protection products used to preserve and protect the condominium property. And then the statute also added a definition for kickbacks, which means anything of service or value for which consideration is not provided for an officer, director, or manager's benefit, or that of his or her immediate family, from any person who's providing or proposing to provide goods or services to the association. 718 now also provides that for residential and mixed-use condominiums, the declaration must include a statement that specifies whether the unit owner or the association is responsible for the installation, maintenance, repair, or replacement of hurricane protection that is for the preservation of the condominium property or association property. Now, that does not mean that you now have to go back and start amending your declaration. But if you are looking to amend, then this would be something that you should consider including. Okay, for electronic voting. So many of you might be familiar that the statute does allow owners to vote electronically on any issue that can come before the membership. Provided that the board has instituted electronic voting. Now, we're not going to talk about here what the requirements are for the board to institute voting requirements, but presuming the board has opted in to use electronic voting, and presuming that many of your owners have opted into the system, just be aware that if the association has instituted electronic voting, then the board has to honor an owner's request to vote electronically at all subsequent elections unless the owner later opts out of electronic voting. So essentially what this means is that if you've given the owners the option to vote electronically and they've opted into the system, the owner can continue to vote electronically and the association cannot refuse that request. The law has also clarified that owners can now also consent to electronic voting by email. Kickbacks. An officer, director, or manager who knowingly solicits, offers to accept, or accepts a kickback commits a felony of the 3rd degree and must be removed from office and a vacancy declared. And a felony of the 3rd degree is punishable for up to 5 years in prison, along with monetary penalties up to $5,000. With regard to insurance, note that if the division receives a complaint Then upon receipt of the complaint, if the association does not maintain proper insurance or fidelity bonding, the division must monitor the association for compliance and may even issue fines and penalties. Financial reporting. Nothing really was changed in terms of the requirements for preparing the annual financial report or the dollar thresholds of the different kinds of financial reporting. Unless your bylaws require you to do an end of the year audit, your level of financial reporting will depend on the annual revenue, and the statute actually provides the different thresholds of annual revenues and the types of financial reporting that you need to prepare depending on your annual revenue. What the statute did change is that the members can reduce the level of financial reporting by vote of the owners. However, you cannot do this. You cannot lower the level of financial reporting for consecutive fiscal years. So, for example, if you are required by statute to do a financial audit, you could have the owners approve a lesser level of financial reporting at one point for any given year. You will just not be able to do that for consecutive years. Okay, so then the following year, you're gonna have to do the financial audit. Debit cards. So while the law already provides that an association, officer, agents, employees may not use debit card used in the name of the association or billed directly to the association, any such person who uses a debit card in the name of the association for an expense that is not a lawful obligation of the association commits theft and is punishable under criminal statute based upon the amount of money expended. These are some interesting requirements for condominium associations. So if you're in a residential condominium association with more than 10 units, you're now required to meet at least once a quarter. So it's not good enough that you meet, either at the beginning of the year and then don't have any board meetings for the summer because everybody is away. You're now required to have at least one board meeting each quarter, and then at least 4 times a year. Now, the statute doesn't say which 4 times a year, so it could be once a quarter, but at least 4 times a year, the meeting agenda has to include an opportunity for members to ask questions of the board. Okay, so you have to have a specific agenda item for owner statements or questions, okay? Now, the rights of members to attend the meeting and the right to speak at such meetings with respect to designated agenda items now also includes the right to ask questions relating to reports on the status of construction or repair projects, status of revenues and expenditures during the current fiscal year, and other issues affecting the condominium. So even if any of these particular items are not on the agenda, owners have the right now to ask questions about them. Now, note that the statute does not necessarily obligate the association to answer any of these questions, but you have to give owners at least the opportunity to ask the questions. Also, if the board is considering approving a contract for goods or services, you now have an obligation to provide a copy of that contract with the meeting notice. And then obviously you have to make the copy of the contract available for inspection and copying upon receipt of a written request for inspection by the owner. So what that means, typically approving a contract for goods or services typically will require just 48-hour notice. Unless, of course, your bylaws provide for a longer period of notice, or if you have other agenda items on that particular notice that might require, a 14-day notice to be mailed or hand delivered to the owner. So obviously, if you're going to, if the notice requirement for this particular meeting is a 14-day notice, you will likely provide a copy of the contract with the notice by mail, hand delivery, or email. Otherwise, if you're just doing a posted 48-hour notice, then you're gonna have to figure out a way to post a copy of that contract with that meeting notice and agenda. All right, structural integrity reserve study, not much was changed. None of the deadlines were modified. Everything pretty much stayed the same. The only thing that was added is this new requirement that within 45 days after receiving your SIR study, the association has to distribute a copy of the study to each owner, or deliver to each owner a notice that the completed study is available for inspection, as well as you have to provide the division with a statement indicating the study was completed and that the association has provided or made available such study to each owner. Of course, the statute doesn't say, what you have to do, if this applies, if you've already complied with your SIRS at some point last year. Obviously, if you've complied with your SIRS at any point after this law went into effect, you should have complied with this requirement. But otherwise, there's no clarity as to whether this applies retroactively or what even would happen if you don't comply. So remains to be seen. Now, if a director or officer is charged by information or indictment with any of the following crimes, they must be removed from office, and we've listed the crimes that are currently in the statute, and they include forgery of a ballot envelope or voting certificate, theft, embezzlement of funds, and then destruction or refusal to allow inspection or copying of official records, which is accessible to owners within the time period required by law, in furtherance of a crime, and as such act constitutes tampering with physical evidence, obstruction of justice, and then any criminal violation set out in Chapter 718. The statute also spells out certain fraudulent voting activities. So a person who engages in any of the following fraudulent voting activities is punishable as a misdemeanor of the first degree, which equals up to 1 year in jail. So we've identified here the fraudulent voting activity that's in the statute. Not going to read them all, just highlight a few. Preventing a member from voting as they intended by fraudulently changing or attempting to change a ballot or ballot envelope, or attempting to perpetrate or aiding someone else in perpetrating fraud in connection with a vote cast. There's a few additional ones here. For example, knowingly aiding, abetting, or advising a person in the commission of a fraudulent voting activity, or even having knowledge of a fraudulent voting activity related to association elections and giving any aid to the offender with the intent that the offender avoids or escapes detection, arrest, trial, or punishment. Okay. There's been a number of changes concerning hurricane protection. So the term hurricane shutters, which was what was used when referring to hurricane protection. That term has since been replaced with hurricane protection. Okay, and remember in the earlier slides, I noted the definition of hurricane protection. So the following provisions essentially apply to all residential and mixed-use condominiums in the state of Florida, regardless when the condominium is created pursuant to its declaration. So it doesn't matter whether your condominium was created 30 years ago, 20 years ago, or it's a recent development. Regardless of whether or not you have what is known as Kaufman language in your declaration, these provisions will apply to your condominium. So among the requirements or among the changes include that the board must now adopt hurricane protection specifications for each building within the condominium operated by the association, which may include color, style, and other factors deemed relevant by the board. Okay, so if you don't currently have hurricane protection specifications in place, you should be adopting them, right? So that if owners want to install hurricane shutters, for example, presuming you allow hurricane shutters, you want to include specifications as to the type, the color, the style of hurricane shutters that owners can install. The risk of not having hurricane protection specifications is that you might not be in a position to deny an owner a request to install certain type of hurricane protection. Okay, so if you want to maintain that uniformity in your condominium, you certainly need to adopt hurricane protection specifications. Now, the statute also says that the installation, the maintenance, repair, and replacement and operation of hurricane protection is not considered a material alteration or substantial addition to the common elements or association property. Obviously, this refers to hurricane protection that is being installed, maintained, repaired, or replaced on common elements. So it's not considered a material alteration. The board may, with the approval of the majority of the voting interests of the condominium, require owners to install hurricane protection that complies with or exceeds applicable code. And then if you do get that owner vote, that certificate has to be recorded in the public records. And then once recorded, the board has to mail or hand deliver a copy of that recorded certificate. Notwithstanding the foregoing, the failure to record the certificate will not affect the validity or the enforceability of the vote of the unit owners, okay? Now, also, a vote of the unit owners is not required if the installation, the maintenance, repair, or replacement of the hurricane shutters or any exterior windows, doors, or other apertures protected by hurricane protection is the responsibility of the association pursuant to the condominium documents, or if the owners are required to install hurricane protection pursuant to the declaration, okay? So if you've amended your declaration, what this means is if you've amended the declaration at some point to require owners to install hurricane protection, they are required to do so, does not require an additional membership vote. I want to just skip to this particular slide and bring to your attention the first bullet point here. So the statute now provides that a unit owner is not responsible for the cost of any removal or reinstallation of hurricane protection, including exterior windows, doors, or other apertures, if the removal is necessary for the maintenance, repair, or replacement of other condominium association property for which the association is responsible. If the removal or installation is completed by the association, the cost incurred by the association may not be charged to the unit owner. If the removal or installation is completed by the unit owner, the association must reimburse the unit owner for the cost of the removal or installation, or the association must apply a credit. So what this refers to is, let's say owners have hurricane shutters installed, and the association has to have those hurricane shutters removed so that you can complete concrete restoration on the building, perhaps per your milestone inspection. Well, if those hurricane shutters have to now be removed in order for the association's contractor to get to the concrete, well, what this statute now says is that the cost of the removal of these hurricane shutters, as well as the cost of reinstallation of those shutters, presuming those shutters are still code compliant, that cost will be on the association. Okay. I'm gonna skip on to the next thing. There's a lot of information on hurricane protection. If this is something that is affecting your condominium, certainly recommend that you review those provisions with your current legal counsel. Now, there was a change done to the statute of repose. So the statute of limitations and the statute of repose now does not begin to run until the turnover. And this, by the way, will apply to those communities that are pretty recent developments that are looking to turn over, or that may have just recently turned over. So the statute of limitations, the statute of repose now does not begin to run until the turnover, when the owners elect a majority of the members to the board. In the past, with construction defect claims, they were limited to 7 years from the date of the certificate of occupancy. Now the statute was changed to provide for a 7-year statute of limitations or repose from turnover. So it's extended the time frame. So this is important if you're looking to pursue a construction defect claim against possibly the developer. All right, SLAP suits. Excuse me. A SLAP suit is a retaliatory action by the association when an owner complains to local government, and then the association sues the owner. So I'm sure none of you have, the 1 or 2 owners that are constantly filing complaints with the division or, with some other agencies. But believe it or not, that does happen in the condominium world. Many associations have that 1 or 2 owners that constantly complain. Now, there are SLAP suit prohibitions such that the association cannot file an action against a member in retaliation for when such member sues the condominium. So in other words, no retaliatory lawsuits will be allowed, or are allowed now under the statute. Obviously, in order for an owner to raise the defense of a retaliatory conduct taken by the association, the owner must have acted in good faith and not for improper purposes, such as to harass or to cause unnecessary delay or for frivolous purposes. Okay. So, in other words, what the statute now provides is that it's unlawful for a condominium association to file any of these, a SLAP suit essentially, or bring or threaten to bring an action or civil action such as defamation, libel, slander, tortious interference on conduct of the unit owner, because the owner has done any of the following, okay, such as if the owner has complained in good faith to a government agency charged with responsibilities to enforce building or health codes, or if an owner has organized, encouraged, or participated in owner organization, or if the unit owner has exercised any of the rights provided to owners under 718. Or number 6, a unit owner has made public statements critical of operation or management of the association. Okay. Many communities have those two owners that are often very critical of the board and what the board does. I mean, owners are entitled to scrutinize the operations and the conduct of the board. Okay, so just be mindful. Can't just file a defamation or libel claim against such owners. Best that you discuss this particular issue with your legal counsel if you have such owners in your community. So in addition, condominium association may not expend association funds in support of a defamation, libel, slander, or tortious interference claim against the owner or claim against an owner based on the aforementioned act conduct. Okay. Now, a few other smaller changes to the condominium statute. SIRS was added to what must be included in the developer turnover inspection report. So the developer now needs to also provide a copy of the SIRS with its turnover report. For conflict of interest, the statute clarifies that a director who has a conflict of interest can establish quorum at a board meeting to allow a vote to proceed in his or her absence. So a director essentially that has a conflict of interest and is looking to enter into a contract with the association for services, that director can come to the board meeting. You can establish quorum with that individual. That board member can do some form of presentation, and then that board member will have to recuse themselves before the so that the board can vote on the transaction that is potentially subject to the conflict of interest. With suspension of voting rights, nothing has changed in terms of the process by which you can suspend voting rights, but there is the new change is that it now requires that at least 90 days prior to an election, written notice must be provided to a unit owner that their voting rights may be suspended due to non-payment of a monetary obligation. So you have to provide that owner at least 90-day notice that they could have their voting rights suspended. Jurisdiction of the division. Many of you might be aware that the division does have jurisdiction to review certain types of complaints, and historically their jurisdiction was limited to complaints concerning official records, access to records, elections, and then financials. So anything regarding financial issues. The statute now has broadened their jurisdiction and includes additional types of complaints. So the division can now review complaints concerning procedural aspects of meetings, including owner meetings, quorums, voting requirements, proxies, issues concerning disclosures of conflict of interest, removal of directors and officers, and then procedural completion of the SIRS, as well as complaints concerning written inquiries. The division is now obligated to refer to local enforcement authorities any person whom the division believes has engaged in fraud, theft, embezzlement, or other criminal activity, or when the division has cause to believe that fraud, theft, embezzlement, or other criminal activity has occurred. And also be aware that the division director or any officer or employee of the division, as well as the condominium ombudsman or any employee of the office of the condominium ombudsman, may attend and observe any meeting of the board or unit owner, including subcommittees, which are open to members of the association. Okay. The next few slides concern the My Safe Florida condominium pilot program. I'm going to, in the interest of time, skip through some of this. Feel free to review these if this is something that you're still interested in. But I'm not really going to spend some significant time on that. All right. Let's go on to homeowners associations. These board members have been patiently waiting for their turn. Okay. So the statute now provides that officers and directors of an association are subject to section 617 0830 of the Florida statute and have a fiduciary relationship to its members who are served by the association. For those of you who might not be familiar with chapter 617 of the Florida statute, it is the chapter that also governs not-for-profit corporations. So as you may be aware, your association is a corporation. It's a not-for-profit corporation, but it is an entity, okay? And it is governed under chapter 617 that addresses not-for-profit corporations as well as general corporate governance. In addition, your association is also subject to either 718 or 720, depending whether you're a condominium, okay? But this chapter 617 does apply to associations, okay? And for your reference, we've provided to you what section 617.0830 provides, which is the general standards for directors. A director has to discharge his or her duties as a director in good faith, with the care an ordinary prudent person in the like position would exercise under similar circumstances, and in a manner he or she reasonably believes to be in the best interest of the corporation. Okay. And then in discharging his or her duties, a director may rely on information, opinion, reports, and statements, including financial statements and other financial data, if prepared or presented by one or more officers or employees of the corporation who the director reasonably believes to be reliable and competent in the matters presented, legal counsel, public accountants, or other persons as to matters the directors reasonably believe are within the person's professional or expert competence, or a committee of the board of directors which he or she is not a member if the director reasonably believes the committee merits competence. In other words, as a board, you're not expected to know everything there is under the sun relating to how to run a corporation or much less a community association, right? And so you have to be able to rely on certain professions and certain experts, okay? So yes, seek the legal guidance of your legal counsel. Seek the advice of your CPA and your engineers and your contractors. You are, required to do that. All right. Financial reporting requirements. Nothing has changed in terms of the levels of the monetary thresholds for your financial reports. So I've included them here in the slide. This is what your statute provides. So the level of financial reporting that you have to prepare will depend on your annual revenue, and I've provided here the thresholds. What the change that was made to the statute is that an association with at least 1,000 parcels shall prepare audited financial statements, notwithstanding the association's total annual revenue. Okay, so for HOAs, even if your annual revenue falls under the $500,000 threshold, if you have at least 1,000 parcels, you are required to prepare financial audit. This is your end of year financial audit. Again, just like for condominium associations, HOA associations also have the ability to have the financial, the level of financial report reduced by a vote of the members. So if a majority of the voting interest votes in favor of it, you can prepare an end of year financial report that's lesser or lower than what you're required to do. But again, as with condominium association, an association may not prepare a lesser financial statement for consecutive fiscal years. Okay, so just be aware of that. For HOAs, an association, its officers, directors, employees, and agents may not use a debit card issued in the name of the association or bill directly to the association for the payment of association expenses. Credit cards are still okay. Debit cards, not so much. And then a person who uses a debit card issued in the name of the association or billed directly to the association for any expense that is not a lawful obligation commits theft as provided in section 812.014 of the Florida statutes. This was an interesting change to the HOA statute. So a parcel owner can now make a written request to the board for detailed accounting of any monies that the owner owes to the association. And if you receive this written request for accounting, the board has to respond within 15 business days of receiving the request. Now, once an owner makes this request for accounting, they may not request another detailed accounting for at least 90 calendar days. Now, if the board fails to comply to this request for accounting within the 15 business day period, then that essentially constitutes a waiver of any outstanding fines that this owner may have, which is more than 30 days past due and for which the association has not given prior written notice of the imposition of the fine. So presuming you've properly followed the statute, excuse me, for imposing a fine. If this fine is 30 days past due and this owner makes a request for accounting of records and you don't comply, then essentially your failure waives their fines. The statute also includes a similar provision concerning kickbacks, similar to that of the condominium. So an officer, director, or manager may not solicit, offer to accept, or accept a kickback. And a kickback is also defined as anything or service of value for which consideration has not been provided for an officer, director, or manager's benefit or the benefit of a member of his or her immediate family from any person that's providing or proposing to provide goods or services to the association. So if an officer, director, or manager knowingly solicits, offers to accept, or accepts anything of service of value or kickback, then that commits a felony in the 3rd degree. And if the board finds that an officer or director has violated the subsection and has received a kickback, the board must immediately remove the officer or director from office. And then the vacancy has to be filled according to law. However, the statute does say that an officer, director, or manager may accept food to be consumed at a business meeting with a value of less than $25 per individual, or a service or good received in connection with trade fairs or education programs. So there are trade fairs, expos throughout the state and multiple locations, throughout the year That's when vendors that service community associations, you know, they're present in these expos. They usually have a booth, a table with goodies, and board members and managers are invited to walk around, meet some of the vendors. You are okay in accepting those goodies and having lunch on these expos. So that's not considered a kickback. A director or an officer charged by information or indictment with any of the following crimes must be removed from office and a vacancy declared. They include forgery of a ballot envelope or voting certificate used in an association election, theft or embezzlement involving association funds, destruction or refusal to allow or copying of an official record of an association in furtherance of a crime, okay? Obstruction of justice, and then any criminal violation under the chapter. All right, there were a number of changes made concerning architectural control. So, as a general premise, right, the authority of the association or any architectural committee to review and approve plans for specifications regarding the location, size, type, and appearance of any structure, or to enforce standards shall be permitted only to the extent that the authority specifically stated or inferred from your governing document, right? So whether or not you as a board, you have the ability to approve or disapprove certain alterations to the exterior of the lot, well, that depends on whether or not you have authority in the declaration, not in a policy, not in a rule, but in the actual declaration. Okay, assuming you do, then the following changes would certainly affect you. One of the changes, while it seems common sense, it is now codified. So the association or an architectural control committee must reasonably and equitably apply and enforce on all parcels the architectural and construction improvement standard authorized under your governing documents. And the association or the architectural committee may not enforce or adopt covenants or rules that either limit or place requirements on the interior of a structure that is not visible from the parcel's frontage, adjacent parcel, or common area, or community golf course. So this, for example, you know, might not be applicable to those communities that are single family, that have single family homes. But if you are in a community where, you know, you have townhomes, you have sharing of walls, and yet you're an HOA, you know, this could be potentially problematic for your community, right? Because now you cannot, require approval for any alteration within the unit that you can't see basically from the exterior, okay? But if that alteration or that improvement will affect you know, shared wall, you know, that could be a problem. You also cannot enforce or cannot adopt a covenant or rule that requires review and approval of plans or specifications for a central air conditioning, refrigeration, heating, or ventilation system by the association or an architectural committee if this system is not visible from the parcel's frontage, adjacent parcel, an adjacent common area, or community golf course, and is substantially similar to the system that is approved or recommended by the association. So can't require basically approval of the AC unit if you can't see it from these points. If you deny a request for an architectural change, you are now required to provide written notice to the parcel owner stating with specificity the rule or covenant which the association of committees relied upon when denying the request, and the specific aspect or part of the proposed improvement that does not conform to the rule or covenant. So I'm familiar with many associations that have an architectural ARC form, right? That typically owners have to complete and then provide copies of the specifications or color samples to the ARC committee or the board for approval. And typically at the bottom of these forms, there is either an accept or denial line that you either check off and then you sign off. Well, that is no longer going to be sufficient if you deny a request. You actually have to let the owner know the specific covenant that you are relying upon, and then what part of the proposed alteration or improvement does not conform with your existing specifications. This was a change to the statute that actually went into effect a couple of years ago. There was just a minor tweak. Essentially, this provision says that regardless of what your covenants or your rules provide, and unless prohibited by general or local ordinance, an association may not restrict a parcel owner or tenant from installing, displaying, or storing any items on the parcel which are not visible from the parcel's frontage, an adjacent parcel, an adjacent common area, or community golf course. So the change here was the community golf course, including but not limited to artificial turf, boats, flags, vegetable gardens, clotheslines, and recreation vehicles. So if you can't see it, you can't prohibit it, essentially is what this says. Oh, yes, holiday decorations and garbage cans. So the statute now says that the association may not levy a fine or impose a suspension of use rights for the following: for leaving your garbage cans on the curb or end of your driveway within 24 hours before or after designated garbage pickup days, or for leaving holiday decorations or lights on the structure and improvement on a parcel that is longer than indicated in your documents, unless such decorations or lights are left for longer than 1 week after the association provides written notice of the violation to the owner. So you have to provide written notice of the violation, wait a week, and then potentially look to fine or impose a suspension. Pickup trucks. This was a big one last year. Pickup trucks and work vehicles, or what many refer to as commercial vehicles. So under the current state of the law, the governing documents cannot prohibit a property owner, tenant, guest, or invitee from parking his or her personal vehicle, and that includes pickup trucks on the property owner's driveway or anywhere within the property where the individual has a right to park under state or county municipal ordinances or regulations. Similarly, regardless of any official insignia or visible designation on the vehicle, the governing documents may not, or rules may not, prohibit an owner, their guest, tenant, or invitee from parking their work vehicle, which is not considered a commercial vehicle. So a commercial vehicle is actually a term of art, and I believe it's in the next slide. So according to the statute, a commercial vehicle is technically a vehicle that has a gross weight of 26,001 pounds. That is what the statute considers a commercial vehicle. So going back to the restriction, unless that work vehicle actually is 26,001 pounds, okay, The statute says you can't prohibit that vehicle from parking in your community. So Joe's plumbing truck gets to stay according to the statute, right? Now, whether or not this particular section of the statute applies to your specific community will depend on whether or not you have what is known as Kaufman language. Okay, now I'm not going to go in detail here of what Kaufman is. It's essentially the magic words as amended from time to time that is typically found after reference to 720 in your declaration. And you'll typically find that within the first few pages of your declaration of covenants. And if you do have that Kaufman language, then what that means is that substantive changes to the statute like these will apply retroactively to your community. And if you do not have Kaufman language, then what that means is that you can make a constitutional argument or take the position that substantive changes to the statute like these ones do not apply to your community. So if you have in your declaration a restriction that says no pickup trucks or no commercial vehicles can park in the community, you could conceivably enforce that provision regardless of what the statute provides. And, the basis of this is that there is this, constitutional premise that the legislature can't adopt laws that infringe on existing contracts. And as you may know, your declaration of covenants is a contract between the association and those owners that purchase lots in the community. So the legislature can't adopt these laws that infringe on the contract, on your declaration, with the restrictions that you have. Okay. Now, we have not seen this concept being challenged in court. So, how a court would rule is yet unknown. There's no legal precedence for this, so just be aware. So the moral of the story here is before you enforce any, vehicle restriction in your governing document, speak with your legal counsel whether or not you have basis to do that, and whether or not it's advisable. Okay. Now, contractors. The statute also says that your governing documents cannot prohibit a property owner from inviting, hiring, or allowing entry to a contractor or worker on the owner's parcel solely because the contractor or worker is not in the preferred vendor list of the association. Okay. The association also cannot preclude the owner from inviting, hiring, or allowing entry to a contractor solely because the contractor or worker does not have a professional or occupational license. And the association may not require the contractor or worker to present or prove possession of professional or occupational license to be allowed entry onto the property. Again, I think whether or not this is something that would apply to your community, if something that whether or not this needs to be enforced by you, again, will depend on the Kaufman language. All right, a few changes were made to the fining grievance committee process. The fundamental procedure of fining and suspending use rights was really not changed. Still the same with the following changes. So the fine or suspension. So after the fine or suspension is levied by the board and you've given the 14-day notice of the committee hearing, that hearing now has to be held within 90 days of issuance of that notice. Okay. So not only do you have to give 14-day notice of the committee hearing, but that hearing itself has to take place within 90 days. And then, as you may know, the committee has to consist of at least 3 members appointed by the board who are not officers, directors, employees of the association, or spouse, parent, child, or sibling of the director, officer, or employee. The committee can hold the hearing by telephone or other electronic means. And access information to join the telephone or electronic email meeting must be provided to the owner. And then within 7 days after the hearing, the committee has to provide notice to the parcel of its findings, including any applicable fines or suspensions that the committee approved or rejected, as well as basically how the violation still has to be corrected. Now, if the violation has been cured before the hearing, then the fine or suspension cannot be imposed. If the violation is not cured and the proposed fine or suspension levied by the board is approved by a majority vote, the committee must set a date by which the fine must be paid. And that date must be at least 30 days after delivering written notice of the hearing results. And then you are entitled to attorney's fees and costs, right? But they may not be awarded against the parcel owner based on actions taken by the board before the date set for the fine to be paid. And if a violation and the proposed fine suspension levied by the board is approved by the committee and the violation is not cured or the fine is not paid, reasonable attorney's fees and costs may be awarded to the association. Also a change regarding fraudulent voting activities. So a person who engages in any of the following acts of fraudulent voting activities relating to association elections commits and constitutes a misdemeanor in the first degree. So we've included here what they include. I'm going to read through them, but here they are so you can review them at your leisure. Each of the following crimes constitutes a misdemeanor in the first degree. Knowingly aiding, abetting, or advising a person in the commission of fraudulent voting activity, agreeing, conspiring, combining, or confederating with at least one other person to commit a fraudulent activity, or having knowledge of a fraudulent voting activity related to association elections and giving any aid to the offender with the intent that the offender avoid or escape detection, arrest, trial, or punishment. However, this does not apply to a licensed attorney giving legal advice to a client. Okay, other smaller changes. Interest, if there is no rate provided in your declaration or bylaws for interest, then simple interest accrues at 18%. And of course, this refers to interest on delinquent assessments. So provided your governing documents authorize you to charge interest on a delinquent assessment, if your documents are silent, then interest will accrue at 18%, which is the highest rate currently provided in the statute. However, notwithstanding the declaration or bylaws, compound interest may not accrue on assessments and installments on assessments that are not paid. Okay. Electronic voting, a few changes. Similar with condominiums, boards of HOAs can elect to institute electronic voting. And then owners can opt into the system if they wish to vote electronically. Associations may conduct elections and other membership of votes through an internet-based online voting system if member consents electronically or in writing. So it does allow owners to consent to online voting via email. And then the association has to provide each member with a method to authenticate the member's identity to the online voting system, a method to confirm at least 14 days before the voting deadline that the member's electronic device can successfully communicate with the online voting system, and then a method that is consistent with the election and voting procedures in the association bylaws. First responder vehicles. An association may not prohibit a first responder as defined in section 112.1815 of the Florida statute, who is a parcel owner, who's a tenant, guest, or invitee, from parking his or her assigned first responder vehicle in an area where they're allowed to park. And I provided here also definition of what is a first responder vehicle, which means a law enforcement officer is defined in section 943.10, a firefighter or an emergency medical technician that's employed by state or local government. Okay, so if you have an owner who is a police officer, they can park their police vehicle in the community. This is a law that it went into effect under House Bill 59. The deadline for compliance has passed, but just so that you're aware, before October 1st of 2024, the association is required to provide physical or digital copy of the association rules and covenants to every member of the association. So hopefully you've already complied with this. If not, get to it. These were the requirements that you were supposed to follow to comply with that. There's also a requirement for the association to adopt hurricane protection specifications for each structure or improvement on a parcel that's governed by the association. This applies to all HOAs, regardless of the date created and regardless of whether or not Kaufman, okay? So you need to adopt hurricane specifications if you haven't done so already. And the specifications can include, color, style, hurricane, color, style, material, really, or any other factor that's deemed relevant by the board. And if an owner does install any particular hurricane protection that's in compliance with your specifications, well, you will not be able to deny their request. All right, some last minute changes here. The term hurricane protection is also identified in the statute. All right, and then there are some there's some smaller bills that were also passed that affect not so much HOAs. This affects Chapter 721. So for most, this will not apply. This has to do with timeshare communities. So again, might not apply to you, but we've provided them here. There was a change to section 723 of the Florida statute concerning mobile home communities. Again, might not apply to most, but here are the changes to mobile home communities. This certainly does not apply to associations, but again, it was a change to a statute, and so the division required us to put it in the slide. So here it is for those who are interested. There was change to legislation relating to licensures requirements, including reciprocity. Again, not necessarily quite on point. Lastly, and the last 2 minutes of your time, there was a requirement early on under the Federal Corporate Transparency Act. Many of you were probably tracking the saga on this, but essentially the Corporate Transparency Act required entities, which did include associations, to provide and disclose certain information regarding beneficial owners. Well, beneficial owners of associations were considered directors. Okay, so there was certain information that had to be disclosed by a certain time frame. just note that as of now, this requirement is at a standstill. So there's currently no requirement for this. Whether this is going to change or not remains to be seen. But right now, there is no requirement to comply with the CTA. All
How
right.
many times did that sucker go back and forth? What was it, like 6 or
It was
7
like ping
times?
pong.
No. I'm convinced that the people trying to pass that thing were also selling like neck pain medication or something to, get you to buy their. So anyway, thanks for smiling at my bad dad joke. That was terrible, but
That was a
great
good
job.
one.
So I know you're all going to go through some of the Q&A. There are a lot of questions there, but again, we're not here to answer a ton of questions. We're here to get you your managers, your CEUs, and some general information. So the gang will go over a few of the questions in the Q&A. While they are looking over some of the questions in the Q&A, I am going to reiterate a couple of things in the chat area, not to be confused with the Q&A, but in the chat module. As we explained earlier, I placed the link for the evaluation into there a couple of times already. Click on that link, fill out the evaluation. I'll go over it much more slowly after the Q&A. I will even share my screen and show you all how to do it if you're having any issues. But for now, I'm going to turn it back over to Kirsten, Carla, excuse me, and Taylor to go over some of the Q&A.
All right. So let me.
Carla, I know you had something you mentioned earlier that you wanted to ask Kirsten.
Yes, I was seeing a couple of questions regarding the website. There are several of them. And in the case of the required website, Rizzetta offers a homeowner portal, which is available via online and the web, and they can access, all the information through there. The app, it's considered also a website, right? For every community.
I don't know if it's considered a website, but it is an alternative. Yes.
But it fulfills the requirement, what I meant to say.
Well, I mean, as long as it meets whatever requirements are in the statute, it should. Yes.
Okay, perfect. And then I was seeing also another question regarding the website, whether if they need to post the records, all of them, the records request of homeowners.
No, it's not all the records. The statute does identify the records that need to be posted, which it's not all of them. I mean, there are on the slides. So once the listeners receive their slides, definitely go through it. It's definitely less than all.
Okay. And also for the website, does it need to be ADA compliance with audio and visual accommodations?
That's a good question. I mean, the statute doesn't necessarily address that, but ADA does not apply to community associations generally. It's Fair Housing Act. I'm not aware that there's any specific requirements for that, but again, I would defer to speaking with the association's legal counsel on that particular question.
Yeah, and we have another question regarding notices via email. An association has stopped posting the meetings online, so owners do not have, they don't receive the notices. And do they have to re-register for them to receive online notices?
I'm not sure I understand the question, but in order to be able to receive official notices electronically, they have to consent in writing, which can be via email. But the board needs to have that written consent on file. If you don't have a written consent, then you have to use other form of official notification, which would be by mail or hand delivery.
Okay.
I'm going to supplement what the person could have meant as the firm's resident nerd over here. Let's assume all the consent has been made official, everything was done properly, you have it on file that they want to receive official business via email. It is not up to the management company to make sure that emails properly get received. It is up to the individual to make sure that they search the spam folders, they enter the name into the contact list. It is on the onus of the owner to make sure that they get the emails received properly once they have properly signed up to receive the emails. Am I making
That's
sense?
correct. Yep, that is correct.
Okay.
Yeah. And then we have another question regarding board members, I mean, probably committees, says, do education requirements apply to officers that are not on board members?
The way it's currently drafted, it's for directors. Right, so if you're an
directors.
officer that's not a director, it seems like it wouldn't apply to you.
Uh-huh. And then we have another question about privacy. Homeowner privacy says, when a owner votes by mail or electronically, how can the vote be kept anonymous? Is there any law that covers owners' privacy?
Well, I mean, if we're talking about, condominium elections, I mean, that the two envelope system, that's what that is intended to preserve, anonymity, right? With HOAs, it just depends on what the election procedure for HOAs is, whether you're allowed to, require the two envelope system, absentee ballots, but with HOAs is a little bit tricky because it really depends on the governing documents. It's not so much, statutory.
So we'll refer to legal counsel for that.
Yeah, you have to have your legal counsel review your election procedure.
Then we had a couple other questions regarding the debit card purchases versus the credit card. Can you explain that with an example? Like, when is it appropriate to use the debit card? Say if they go buy a
They
lunch.
shouldn't be. They shouldn't be. I mean, those are, prohibited. Credit cards seems to be okay still. But debit cards is a no-no going forward.
Yeah, and Mary just asked, what about a deposit-only debit card? If it says debit card on it, just don't do it. If it has the word debit on the card, do not.
No.
Yeah, err on the side of caution.
Yeah, and there was another question about in violation of the $25 threshold. So if someone gets invited to a golfing event that is sponsored by the community or by someone, that's over the $25 sponsor. So not attend or do attend?
I mean, who knows? I don't know how much that would be, but I mean, if you have any shred of doubt, then maybe not attend. That's the best thing.
Yeah,
And if it's food, it's Sizzler, not Ruth Chris Steakhouse. TGI Fridays.
Although I have to say, the food at the trade show is not bad. All right, maybe one or two more, and then I have to get off.
Perfect. There's one question regarding the shutters. What if the shutter that was installed it's causing leaks into the unit? This is for a condo. Who is responsible to make the repairs or remove the shutters? It will boil down to the governing documents, or is it?
Well, I mean, are we talking about repairs to the exterior envelope of the building, right? Because that would be an association responsibility.
Right.
I'd presume you have the association has hired some kind of engineer or accountant or a contractor to confirm, the source of the leak. If something has to be done to the exterior of the envelope, then those shutters will likely need to be removed. The way the statute currently reads is that the cost of the removal is on the association. If there's any damage inside the unit, it depends. You know, is it the unit? What part of the unit is owner responsibility and then association responsibility per the governing documents?
Mhm. Okay. And the last one, for 718 slab, is there something similar for 720?
I'm sorry, for 718.
The SLAPP.
Oh, slop suits. Oh, geez. Trying to go off the statute of memory. I'd have to look, to be honest.
Mhm. All
I
right.
don't want to say the
Thank
wrong
you.
information.
Yeah. There were so many great questions there too.
That is
Sorry
true,
we couldn't
yes.
cover all of them.
Well, thanks everybody. Now, for those of you that are still here, hang out if you're having trouble downloading the slides or not sure how to do it. After everybody gives their parting words and their final goodbyes, I will remain on. I'll go over the evaluation process while I share my screen much more slowly. So, everybody, the best way to get in touch with you, let's first start with Taylor and Carla.
Yeah, thank you all. Thank you, Kirsten. Super informative, a lot to unpack there, and thank you for that. Again, a lot of information. If you guys need to view it again, take a look at either our YouTube channel. The link will be found on our website. It's www.rizzetta.com. Just want to say thanks again for attending, investing your time, Kirsten, and everyone else here from the board and the industry for being here. And I hope you have a great rest of the day. So thank you again for joining us.
Thank you. Kirsten?
Yes, again, thank you so much, Carla, Taylor, for having me. This was a pleasure. Hopefully we can do another webinar that's not as long and we offer many other many other
Yes,
courses.
we have some ideas working on. So thank you so much everyone for attending. We'll send you the recorded video in a couple of days. And if you have any questions, please answer the survey at the end. We'll be happy to help you. So thank you for attending, and thank you, Kristen, Jeff. You guys are awesome. So thank you.
Thank you both. We look
Thank you
forward
all.
to the next time.
Yes.
Bye.
Bye.
Bye, everybody. So, folks, I'm going to share my screen now. In the chat area, I placed the link once again. And when you click on that link in the chat, if you have a pop-up blocker on your browser, just copy and paste the link into your browser. That's another thing you can do if it's not working. But after you click on the link, it takes you to this screen here. This is oops, let me just make that a little smaller there. Okay. Takes you to this screen here. You fill this sucker out. Anywhere you see a little asterisk, it's a required field. Those of you who are saying that it's not submitting properly, the most common error is you try putting the city into the zip code section, and that zip code section only takes numbers. So the field is above the description. So city, the field for city is above city. The field for zip code is above zip code. If you're on a phone or a small device, turn it sideways into landscape mode. It'll be easier to read. So after you fill this out and hit submit, this is your confirmation screen of a successful submission. And all of the contact information is here for Kirsten, for Rizzetta, questions about the class, one of our upcoming meetings, which is Monday the 30th right there. The second bullet says click here to download and save the slides. I saw a couple people asking about how to save the slides. So after you click on the word here, in a new tab, the slides open up. Now, what I'm going to mention now is not something that will work for everybody uniformly because everybody has a different computer, a different browser. If you have the same browser, I might have the new version. You might have 4 generations old version. So can't control that. But something that tends to work with everybody and every browser, every operating system. Once you see the slides open, if you can't easily find the download or save buttons, like here on my latest version of Chrome, they're right up here, the printer or the download. What you can do, which typically works for everybody, is go on top of the slide, go put your mouse pointer on top of the slide, right click with your mouse, And then the little window opens up with a save as or a print, and you can choose one or the other and then download it onto your computer that way. I opened up the chat so you could ask me some technical questions in there. So let's see if you have any questions or issues. You can put them into the chat right now and ask any questions you might have. Keep in mind, keep the questions to technical issues or class-related questions that are non-attorney related. Even if I know the answer, I'm not going to reply and pretend to practice being a lawyer. So technical questions only, please, if anybody has anything. I'll stay on for a couple of more minutes. To address the portal website question that somebody had earlier, a lot of people use the word portal, website, and app uniformly. Okay. Uh, and pretty much they are, but in terms of what a portal is a place where you sign in to see a protected section of the website. So let's say you have an existing website already, just showcasing your amenities or whatever it might be. You can then just add a portal to the existing website. So that's typically the difference. So if you have an existing website, and I believe Rizzetta offers portals, which is what Carla mentioned earlier. So a great management company like Rizzetta,
Yes,
you
we
can
do.
just add a portal. Let's say you do, okay. So let's say you already have a website and you sign a contract to work with Rizzetta as your management company tomorrow. So you want to take your existing website and just add Rizetta's portal, you can do that without changing your
Exactly.
existing website. Correct, Carla?
Exactly. That we can embed it into their existing website, or if they have something like us, we transfer all the files from that app. It could be like Town Square that it's mainly used for other companies, or Caliber, or things like that. We transfer all that data to our homeowner portal.
Excellent. Excellent. Thank you for clarification. I'm glad you're still here to hang out and see how we do things because I have a feeling we'll be doing some more together real soon.
Yeah. When you said technical, I was like, oh, let me stay.
Yeah. Do you have any questions? I mean, this is also what I do. If you have any questions, Carla, I do community association websites too. At least I used to. So, but another question earlier that we had that is non-attorney related. Somebody was asking about why don't we separate the HOA,
Oh,
the condo stuff.
HOA with condos, yeah.
This class is for managers' credits.
Yes,
They have to
exactly.
receive all of this information, whether it's condo or HOA. In order for camps to receive credit, we have to cover everything. That's why this class is all in one, this legal update. Once
Yeah.
we get the clarification from the state about making HOA board member CEU classes and the
Reviews.
condo once a year legal class that they have to do, those will be specific to those associations and geared more for board members only. Managers will be
Exactly.
welcome, but they will be board member specific classes. So that's another couple of questions that came up in the Q&A earlier.
Yeah, that is correct. We will do a series and a live webinar on that once we have the clarification.
Yeah. Yeah, we did get the letter and we did submit courses for HOA CEU approval, but they came back and said we need to send them even more stuff, even though their letter to us initially didn't have that stuff on there. So this is all new to everybody, even people at the DBPR. It's a
And
learning
we are,
process. So
yeah,
get it right. Everybody will, by this time next year, it'll be second nature.
exactly.
Thanks, Diane. Thanks, Marty. Thanks, Shannon. Thank you, Belkis.
Thank you. Thank you, everyone.
All right, I don't see any technical questions. We're going to head out. Carla, nice meeting you. And
Nice meeting you
second time.
virtually so many times.
So we'll see y'all next time. Everybody have a
All
great
right. See you.
day.
Bye.
Hydrated.
Thank you.
Hot out there. Take care.
Stay hydrated.
Bye-bye.